The stakes are huge for preserving free speech on the internet. I think the fundamental question is who decides how information should be transmitted and accessed over the internet? Should it be the government or the people? Net neutrality proponents believe that the First Amendment interests at stake here are those of internet users, who should have a First Amendment right to access whatever content they want on the internet. The net neutrality activists would argue that broadband providers have an incentive and ability to discriminate against certain content providers and to extract fees or tolls to access end user customers. The First Amendment protects broadband providers because they engage in and transmit speech. Broadband providers perform the same function as a printing press, a news rack, a cable system, a broadcaster, a movie theater. These are all transmitters of third-party content. They engage in editorial discretion in deciding what content should transmit their networks. So net neutrality activists and the FCC would argue the First Amendment doesn't apply at all to broadband providers. They're just like a telephone company. Both are classified as common carriers, and common carriers have never been viewed as engaging in First Amendment activity. So transmitting content over the internet is fundamentally different than transmitting content over a telephone wire. Telephone companies traditionally transmitted private communications between individuals, and historically there's never been viewed as a First Amendment interest. Broadband providers, by contrast, engage in public communications. And when you're engaging in mass communications or transmitting them, you're acting more like a broadcaster or a cable operator or a news rack. And those activities are protected by the First Amendment. In 1992, Congress passed the Cable Act, which contained a provision called the must-carry statute. The must-carry statute required cable operators to transmit a certain percentage of broadcast television stations over their cable facilities, to include them in their cable channel lineups. The cable operators sued and challenged that statute all the way to the Supreme Court, and in a series of decisions called the Turner decisions, the Supreme Court held in Turner 1 that the First Amendment does protect cable operators and that the must-carry statute impinges upon cable operators' protected speech rights. In Turner 2, the Supreme Court upheld the must-carry statute under intermediate scrutiny. The Turner decisions are key to the net neutrality litigation because broadband providers perform the same function as cable operators because they decide whether and how to transmit content over their facilities. When you require a company to carry all content, you necessarily strip it of all editorial discretion that the First Amendment protects. So for example, the no blocking rule says that broadband providers are required to carry all lawful traffic. So what that means is that a broadband provider cannot block Nazi hate speech or Islamic State recruiting videos, even though a broadband provider might disagree with that content. The internet has grown and developed without government control, without government intervention. So the best way to ensure multiplicity of voices on the internet and a wide dissemination of information is for the government not to interfere. It should let ISPs innovate and decide, how they want to offer and communicate their services to their customers.